When a debt is assigned to a third party, the third party, called the assignee, becomes the new owner of the debt. But what if the debtor continues to pay the original creditor instead of the assignee? Is the debtor liable for the resulting damage to the assignee? The New York Supreme Court Appellate Division faced this question in the 1937 case of Continental Purchasing Company versus Van Raalte Company. Ethel Potter, an employee of the Van Raalte Company in New York, owed money to Steckler Sporting Goods Store. At some point, Continental Purchasing Company took over the debt, and Potter assigned all of her earned and future wages to Continental as payment for the debt. Continental notified Van Raalte about the assignment in writing, and Van Raalte acknowledged the assignment. Then Van Raalte suggested a modified payment plan, observing that Potter's weekly earnings were her only source of income. Continental agreed. 6 times, Van Raalte withheld $1.50 from Potter's wages and then forwarded that amount to Continental. But when Potter's situation was referred to a local charity, Van Raalte stopped withholding money from her wages for Continental, even though the debt was not yet fully paid. Continental sued Van Raalte in New York State Court, seeking to recover $19.20 owed on the debt. Van Raalte defended on the basis that it had already paid that amount directly to Potter. The trial court entered judgment for Van Raalte, and Continental appealed to the New York Supreme Court Appellate Division.